Well, let's be clear. Previous life.
All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. When I call your name, please say present or here and raise your hand so I can mark you down as present. Grayson Berry has been verified in custody in the Dallas County Jail. Carl Caver. Carl Claude Caver. Stephen Cross. I see you, but I didn't hear you, Mr. Cross. I might not look up, so let me hear you. Daniel Downing. Daniel Denarius Downing. Kendrick Irvin. Kendrick Lyron Irvin. Marshall Flores. John Mosley. Jaquavian Jackson. I'm going to note that Mr. Jackson is running late. We'll recall his name. Essie Manyweathers. Essie Manyweathers. Christopher Nash.
That's singing voice. You're gonna need it.
Still haven't heard anybody say present or here. Is this thing on? Please say present or here when I call your names. We're 0 for 5. I bat better than 0 for 5. Every now and then I get lucky. Tamara Ream. Thank you. There we go, Ms. Ream. James Rife.
Hey, Your Honor.
Thank you, sir. Ishmael Rodriguez. Luis Vasquez. Luis Julio Vasquez. Jeffrey Viramontes. Thank you, sir. Ladary Ward. Ladary DeAnthony Ward. Dakota White. Ernest Wilkerson. Melody Dollar. All right, Ms. Dollar, I'm going to call you up in just a moment. Mr. Adams is not going to be here. He filed a motion for continuance, and so that's been granted. So I'll bring you up just a second. We'll reset you and get you out of here. Ashley Blair. Ashley Rashawn Blair. Brittany Boyd. Brittany Liddell Boyd. Justin Cannon. Shelby Joslin. Jesse Tashner. Houston Carpenter. Jackie Elliott. Chase Enox. Gary and Hamner. Philip Hollister. I'll call you up in a moment. Lane Swanson. Royce White. Royce Latate White. Veronica Sturgeon. Thank you, sir. Are you Mr. Lacey?
Mr. Cassis.
Mr. Casillas, thank you. Theodore Houston. He's in the very back. Mr. Houston, I want you to come on, and I'm going to give you your analysis test before I call your case. So come on back here and meet with Officer Matura here, and she'll give you further. Or actually, there's Officer Waddell right there. Jason Jones. Christopher Nicely. I have a note that he states that he has COVID. He's to provide documentation. I don't know, Mr. Knoll, you know anything about that? Okay, we'll recall it, figure it out. Travis Skinner. Dennis Jones. James Bustamante. Joshua Hand. Joshua Ray Hand. Ralph Hansekla. Charles Howard. Leonard Purley. Leonard Wagner Purley. John Pigney. John James Pigney. Avery Plunkett. I think he may still be in Dallas. We'll recall him. Michaela Williams. I do have a note that Miss Williams indicated that she has car trouble, and she anticipates being here, but being late. Also have a note that Mr. Stevens indicated he'd be here by 10.
That's states are saying, Judge.
We'll recall. Cody Gates. Mitchell Ragland. Thank you, Mr. White. Jeremy Reeves.
That'll be a plea.
Thanks, sir. Isaiah Rosser. Claude Solis. It's Solis, right? And then for the record, Debbie Spriggs, CR 21372, waiver of arraignment filed, granted, approved, pretrial set February 10th. All right, is there anyone who's present in the courtroom? I did not call your name. Your name, sir? Sherwood?
Judge, that case was dismissed yesterday by the court. I spoke to Mr. Wood, trying to speak with Mr. Sherwood. I don't know whether he did or not. That case was dismissed yesterday.
All right, Mr. Sherwood, the state of Texas filed a motion to dismiss in your case. The court granted that and signed it yesterday. So you can contact Mr. Wood. You're free to go. Anyone else? Your name, sir? Hand? Yes, I called your name. When did you come into the courtroom? Okay. Anyone else? I've not called your name. You expect to be on today's docket. All right, counsel, do we have anyone that's ready? Mr. Casillas, are you ready? Veronica Sturgeon, CR 21248. Just come to that podium right there. Has it?
Yes, sir.
All right, these are going to need to be sworn by the clerk. Also, I noticed that this is a drug case, but there's no restitution for the lab. Is that something y'all have worked out that you're not collecting?
I believe it's that last form, Your Honor.
Right, but there's nothing in the contract that orders her to pay it. It's not laid out in the financial restitution and reimbursement zero.
I think there was two different areas of restitution, and one of them says 180.
Judge, I believe it just doesn't reflect in the paperwork. If the court would like to
Well, it
interlineate,
says 180, but it doesn't say if it's per month or she's paid up front or paying in a month. Do y'all, you care?
as long as it's paid during the probationary period, that's fine by the state.
All right, so Mr. Casillas, I want to ask you to take your client to the clerk's office and have her sworn on. And then I'll back in line. I'll get you work back in.
Thank you.
Do my best. Do you have any other counsel that's ready?
Your Honor, I got a couple tasks.
Who do you want me to call it first? Who are you ready?
Mr. Gates.
Cody Eugene Gates. CR 21-217. All right, Mr. Gates, is that reach on today?
Your Honor, at this time, we don't have anything contested. We'll just abide by the court's standing pretrial order. Ask the court to move this over to docket call.
All right, court will find there are no contested pretrial motions, and we'll set Mr. Gates for docket call. Available on February 8th, Mr. White.
I'm sure I will be.
All right, court sets Mr. Gates for docket call February 8th at 9 a.m. Be 1:30 if he is not on bail. Mr. Gates? Yes, sir. I'm going to ask you to step forward. I have a warrant for your arrest. Your bondsman has gone off your bond.
I talked to them last week.
He can talk to you about it.
I understand. Just telling you this, they've gone off. So if you work that out with them and they go back on, then they'll post or they'll ask me to withdraw the surrender, but it's been submitted and signed. So Deputy McLeish is going to take you into custody at this time. And the range of punishment for that type of offense, a second-degree felony, if you were convicted and sentenced by a jury or by a court, the sentence would have to be not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, that is prison, and a fine of not more than $10,000. You understand that range of punishment? And I see here that you want to enter into a pretrial intervention contract with the state of Texas for a period of 2 years. Have you gone over this paperwork with your attorney, Mr. Casillas or Mr. Lacy? You feel like you've had enough time to discuss your case with them and understand everything that you've read and signed today?
Yes.
You have any questions about what's going on in your case up to this point or what's going on today?
Is the DA gonna quit reaching out to my husband?
That's a question I can't answer, but it's a question maybe they can address. But you do read, write, and speak English, is that right?
Sorry?
You do read, write, and speak English.
Yes,
And have you ever been diagnosed with any type of mental condition?
I have combat-related PTSD, ADHD, and OCD.
Are you currently under treatment for those?
Yes, sir.
Are you on medication at all?
Yes.
All right. Do you feel like you have a rational understanding of the proceeding today and what's going on? All right. Mr. Casillas, do you believe your client to be competent today?
Your Honor, I've always found my client to be appropriately oriented to time, place, and circumstances. So yes.
All right. You believe that she meets the legal requirements of being competent?
Yes, Your Honor.
And you've explained to her the pretrial intervention contract, and you discussed with her the waivers that she's making in this contract?
I did, Your Honor, and she has evidenced an understanding of them that was appropriate.
So, Ms. Sturgeon, you understand that you would be waiving a right to a jury trial in this contract? Meaning that if I approve this and I place you in this program and you do not successfully complete the program, you could be brought back to court and scheduled for trial. And that trial would be before the court, not before a jury of your peers. You understand, once you waive that jury, the jury is not going to be restored to you in most circumstances. You also understand that you are waiving your right to confront the state's evidence and witnesses in front of a jury.
Yes, sir.
And you understand that you're also waiving your right to a speedy trial, and you're waiving your right to have your criminal record expunged with regards to the DA's office records and the probation office records. You understand that? And Ms. Sturgeon, has anyone threatened, forced, or pressured you to make you feel like you had to waive any of those rights or enter into this contract? Okay. I understand it may be a little emotional, but you're not under duress today. Is that correct? Meaning you don't feel like you're being forced to do anything today, right?
Not for you guys, no, sir.
Say it again.
Not for you guys, no, sir.
Do you feel like you're being forced by someone else to do it?
Yes, sir.
Who do you feel like you're being forced by?
He's the one that's responsible for this. Ex law enforcement and him and his friends did some stuff, and I can't prove it because he deleted all of my evidence, all my pictures, all my texts, everything.
So would you be telling me today, Ms. Sturgeon, that you are not legally responsible for this crime?
Absolutely not, sir.
Then unfortunately, Ms. Sturgeon, I can't allow you to enter into this program, and I can't allow you to plead guilty, because that's what I would have to ask you here in a moment. And if you're pleading guilty because you're under duress or because you only want to take an agreement to resolve the case,
I have no other option. Like, it's a domestic violence situation. I have three pending cases against them. Like,
I understand, but here's the problem. I have no other choice either. I can't let you plead guilty to something that you're not guilty of committing. The only people that can plead guilty to an offense are the people that stand before me and they say, Judge, I am guilty of committing a crime. And in this case, you would have to be guilty yourself of committing possession of controlled substance. That means you'd have to knowingly possess and control a controlled substance in a certain penalty group and in a certain amount. You would have to know that you're doing it. You would tell me today that you did not knowingly control
no,
or
sir, I
possess.
was completely set up.
All right, so it sounds like there's still work left to be done in this case. So I'm gonna reject the pretrial intervention contract at this time. I'm gonna reset this for an additional docket call. Said, are you or Mr. Lacy available on February 8th, Mr. Casillas?
We'll be here.
Okay. All right, so the court resets Ms. Sturgeon for an additional docket call on February 8th at 9 a.m.
Your Honor, will I get that $500 check back that you for the program?
Judge, I will contact my office and have them hold it. We'll return it to Mr. Casillas.
I'll walk down the street.
If you'll just go
right after
if
we're
you'll go
done.
pick it up, we'll return that, so she can have that back if she. So
All right, I'm also going to return the pretrial intervention contract. I'll get that back to Mr. Casillas.
Great.
That's fine, Judge.
All right, Ms. Sturgeon, once you sign the notice of setting and get the yellow copy, you're free to go. Okay, we'll see you back on February 8th.
8:30 a.m., Your Honor, 9 a.m.
9. Mr. White, were you ready on your other one?
Yes, sir.
No, you got sidetracked for just a moment. I did with your other client. Who was the other client you wanted?
Mr. Souls.
Mr. Solis, CR 21246. All right, set for pretrial today.
Yes, sir. Right now, we don't have anything that's contested. Ask the court to move this over to docket call. I don't anticipate, I will make the court aware of this. There was some issues on a couple of things regarding some old evidence in this case. Anything that won't be dispositive of the matter, it'd be an evidentiary issue. Probably just have to get the out anyway. Expert testimony. And I believe the court's standing order requires that the state if they intend to introduce that. They'll designate their experts prior to this hour. Objection of the dollar. That would be the whole thing. In the state. Very well be decided they don't do anything. Obviously. But the phone question, our phone. So presumably. So they're not going to do that or don't. That would be a reason for us to have it here. So I just have to.
All right, we'll move to docket call. If that issue arises again, just let me know.
Yes, sir, I will. And I'll accept that it's my responsibility if I have any issue with anything that I must get a hearing with your court coordinator prior.
Yes, sir. Yes. All right, Mr. Scholes, court's going to reset you for December. Backwards. February 8th at 9 a.m. You're just working on your pleas for the other case.
Yes, sir, that's what I'm doing.
Okay.
Thank you, sir.
Mr. Schmidt, you ready? You ready, I'm sorry. Is it all of them? Bring them all up one time.
Mr. Howard has an arraignment already on that.
Say Mr. Howard.
I think, yeah.
Charles Howard. CR 2176. CR 21386. All right, Mr. Howard is set for docket call in 76 and arraignment in 386, I believe.
That's correct. On the new charge, the 386 charge, got a copy of that indictment. We've got the discovery as well. We wait formal reading, enter a plea not guilty, asked that would be set for pre-trial and carried with the CR 2176.
All right, court will enter Mr. Howard's plea of not guilty into the record and cause him for CR 21386. We'll set Mr. Howard for docket call and pre-trial respectively. Available February 8th or 10th.
That's fine. Anyways.
February 8th. Mr. Howard, need you to step forward. I have a warrant for your arrest. I believe it's KPS profile warrants.
What is it?
KPS profile warrants means that you didn't pay your fines and court costs in older cases. Warrant was issued after sending notice to you.
Is felony?
CR 1245 and CR 1581, I believe. Your case numbers.
Oh, this one here?
No, not this one. They got felony calls. Just, it works by you get taken into custody and going to jail. I take care of it by putting you in custody and you go in jail, and then you get your paperwork and you figure it out over there. All right, Wood County.
Can you hear me?
Yes, sir, I can. Give me just one. Yeah, give me just one moment. I'm gonna get that up here and just gotta find.
I'll bring Mr. Crane in.
Thank you, sir. I appreciate it.
Yes, sir.
Mr. Knoll, we're calling Mr. Robert Crane with Wood County. Wood County is zooming him in.
Would this be the best place for this, or?
Yes, right there, and yeah, right with that microphone. That way he can hear you. Maybe roll your podium a little closer, and he should be able to see you on the screen. Kind of this way. See the camera? There you go, right there. Perfect. Perfect.
Can you hear me?
Yes, sir. Good morning, Mr. Crane.
Morning.
All right, this is cause number CR 2156, State versus Robert Cecil Crane Jr. We are set for arraignment. For the record, Mr. Crane is appearing via Zoom from the Wood County Jail. And Mr. Knoll, you have been court appointed to represent Mr. Crane. And we're set for arraignment today. Have you had an opportunity to go over the indictment with Mr. Crane?
This, as the court may note, the case is kind of old. He and I, my only actual recollection is we have met, discussed some issues. We probably have reviewed the indictment, but to be honest, he's been in Wood County a while, so
Do you have the indictment displayed so we can go back over it?
that would be probably best, Your Honor.
I'm trying to pull up what's labeled indictment in the clerk's case. The only thing that pulls up is his indigent appointment paperwork. So I'm having a time finding the actual indictment.
It could be that when he and I met, we actually met, I believe, once in the office. We reviewed, I think it was actually at that time, just the probable cause affidavit.
Yes, sir.
As the court may note, the case is almost 16 months old, so it's been a while.
Mr. Crane, bear with me just one moment, okay? I'm gonna step away to see if I can find this document. It's not scanned into the system like it's supposed to be. So give me just one moment. I'll be right back with you, okay?
Yes, sir.
All right, Mr. Crane, we're gonna have to do this the hard way. I'm just gonna hold the document up to my camera and slowly go down and let you read it. All right, so whenever you need me to move down or you're through, you just let me know, okay? So
Yes, sir.
if you can't see it, then you just let me know, okay? So let me see how I can do this here. I'll try to hold this down.
Okay. Okay.
All right. So Mr. Crane, this offense is a second-degree felony offense, which carries a range of punishment not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. The state has also alleged 2 prior enhancement paragraphs. If each one of these enhancement paragraphs is proven to be true, then that could enhance your punishment range to that of a repeat or habitual felony offender, and could result in a punishment range of a minimum of 25 years confinement in the Texas Department of Criminal Justice to a maximum 99 years or life. You understand that full range of punishment?
Yes, sir.
All right, Mr. Knoll.
Judge, my recollection is his name is spelled correctly in the indictment. For the purposes of arraignment, we'd enter a plea of not guilty. Guess the only other information I know that he's obviously in Wood County, and he's been in Wood County, looks like about 10 months. At this point, I have no idea as to whether they have any trial settings. I believe he has 3 charges there. I don't know if he has any trial settings there. I know he has a counsel there, but I don't have any knowledge of any trial settings.
There is no trial settings yet.
No trial settings. And is your name spelled correctly in this document?
Yes, sir.
Okay. All right. Does your client waive formal reading of the indictment?
We would waive formal reading of the indictment and enter a plea of not guilty.
All right. Court will enter Mr. Crane's plea of not guilty into the record, and the court will set Mr. Crane for a pretrial hearing, and we'll set it out. Set it in March. Give you a little bit more time. Do you know if you'll have time to be able to meet with him? I gave you 60 days where you could meet with him to.
60 days, I ought to be able to get up there even if it's a Saturday or Sunday. The only thing I'd ask, if Mr. Crane knows, are there any limitations on visiting at the Wood County Jail for attorneys?
I do not know, sir.
Additional counsel has indicated no, so, but that won't be a problem.
Okay. So what I'll do is I'll set it on March 10th,
Works for me.
8th or 10th. Which one would you rather have? One's a Tuesday, one's a Thursday. Which one better for you?
I like the Thursday.
You like the Thursday? All right. So we'll set Mr. Crane then for pretrial hearing on March 10th. And typically, we set our jail in the afternoon. I don't know if Mr. Crane will still be in custody in Wood County. So let's just go ahead and set it for the afternoon at 1:30. And I'll ask jail staff there in Wood County if they could assist us on that day.
The only other issue that I can think of that might present some technical issues is I assume there's CAC interview in this case. Obviously, we're not entitled to receive it, but we are entitled to review it. And if he's going to be in Wood County, I guess I'll just have to make some kind of arrangements to be able to do that. I don't know what, but something.
We'll just tentatively set it at 1:30, and that's going to be subject to Wood County's availability to help us. And if we need to move that to a time certain, 2:30, 3:30, something like that, just let me know. We'll make it work that day. All right, Mr. Crane, Mr. Knoll's going to try to get up there to see you before March 10th and try to go over all the discovery with you. And then March 10th will just be a pre-trial setting to make sure that we have all of the evidence and we're able to go forward and decide if we're going to have this case to be a bench trial or a jury trial or a plea or something of that nature. Okay.
Yes, sir. Thank you.
All right. Is the jail staff still with you in the room?
No, sir, they're not.
All right. If you'll just let them know, I appreciate their help today and look forward to working with them again. Okay.
Yes, sir. Thank you.
Thank you, Mr. Knoll.
There's Mr. Houston, I think's on the docket. I think he's on page 4, or maybe it's 5.
Theodore Houston, CR 21264. All right, Mr. Houston is set for a docket call today.
He is, Judge, I had hoped to be a little farther along, however, during the Christmas break, I'm not sure how many pages in documents, but I received, as I indicated, a novelette from Mr. Houston regarding the case, which is contained in these files. I also got a DVD that I picked up today. Because of the information and the possibility of needing other witnesses or other documents that might have to be subpoenaed, I would actually ask the court if it could set it the same day as Mr. Crane, that being the 10th, except in the morning, I guess.
If you need 60 days.
I think so, because there's just that much information, and what I've reviewed some would indicate there may be some additional records that I don't have, maybe needed to be obtained elsewhere, and possibly some subpoenas.
Any objection to the state? And also show that Mr. Houston is the legal.
He's paid a token. They're unemployed, homeless.
Show that Mr. Houston is still delinquent on his payments towards pretrial release for supervision and towards his lawyer fees. So it's a little over $100 delinquent, so we need to start working to try to get that resolved as soon as possible. All right. I did drug test Mr. Houston today and he was negative. All right, court will reset Mr. Houston then for docket call on March 10th at 9 a.m. I think if you'll have him sign that notice, once you get the yellow copy, then Mr. Houston, you'll be free to go. We'll see you back on March 10th. Make sure you're still reporting to Mr. Waddell and try to get whatever amount of funds you can together to pay towards that delinquency, okay?
Judge, that on Mr. Neasley, who indicated that he had COVID, in case you called earlier,
You're done with Mr. Houston?
I am, as soon as we can get this, I have sent Mr. Neasley at the only phone number I have, a text message indicating that he needs to get some medical proof of that to the court.
All right, so CR 21-174, State versus Christopher Neasley. Christopher Neasley is not present. His name's been called in the courthouse at 9 a.m. He's not present. Court's not received any documentation towards COVID testing. So the court's going to issue a judgment nisi after his name is called in the courthouse 3 times. If there is no response, the court will issue a judgment nisi. Mr. Knoll, I will take that under advisement until Thursday at noon. It is Thursday. I'm gonna go back in, go back out, go back in. I'm gonna reset this thing all over. So let's see, our next docket date is next week. All right, so I will hold that under advisement until tomorrow. Okay, so if he gets his documentation in, otherwise we will go ahead and reset Mr. Neasley for his hearing. And are you available on February 8th or 10th?
I like Thursdays best, Judge.
Thursdays, all right. So we'll reset to February 10th. We were set for status today. Do we know what the purpose of the status was?
It's for status of a new case. We received a new case. So we received, I believe we were set to complete 1 point. Hopefully we can reach a continued agreement on that, but we will see when Mr. Neasley avails himself in the court. It was set for a status regarding a new case, but the DA's office.
Judge, in fact, we'd actually completed plea papers and had already received the conditions, all the other conditions and everything had been done. But the new case,
I believe he had a warrant, we arrested him.
Right.
Prior to entering a plea to this case, because we were notified that there was a brand new case in the warrant. We received to review that case.
I show that we've never even gotten to pretrial. We went arraignment status. So we'll set this for pretrial on February 10th. And if we reach a plea, we'll take it that day. If not, then we'll move on normal course.
thank you, Judge.
Just tell him he's got until tomorrow to get me some kind of documentation, or that hearing on 210 will be at 1:30. Do you have your paperwork on Mr. Jones? Are you still working on that?
Actually, I have it in my hand now, so well, we lock it now.
Yeah, if you're ready. Jason Jones. And give this to Mr. Jones. Mr. Jones, I'm going to hand back to you the bill of costs that stays with you. This is CR 21297, State versus Jason Jamal Jones. Mr. Jones, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Mr. Jones, are you a United States citizen?
Yes, sir.
And do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Knoll. And are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and reviewed with him and signed that you do not understand? Mr. Knoll, do you believe your client to be competent today?
I do, Your Honor.
You've explained to him all of the paperwork and his legal rights.
I have, Your Honor.
Do you believe he understands them?
I believe that he does.
Mr. Jones, you're charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 2, less than 1 gram. State jail felony carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC and a fine of not more than $10,000. You understand that if I approve this plea agreement today, in which you're asking the court to place you on 2 years deferred community supervision plus fine, court costs, you understand that if you violate the terms and conditions of your community supervision and you're brought back to the court, if the court finds that you violated, the court could adjudicate your guilt, that means convict you. The court could revoke your community supervision and assess your punishment anywhere between that minimum of 6 months and that maximum of 2 years. Understanding those things, do you still wish to go forward with the plea?
Yes, sir.
All right, Mr. Jones, I'm going to ask you this time, how do you plead to that offense? Guilty or not guilty? Are you pleading guilty, Mr. Jones, because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty?
No, Your Honor.
Court will accept the defendant's plea of guilt. Mr. Knoll, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, we would rest it close.
Thank you, Mr. Woodwhite. Mr. Knoll, anything from the defense?
No, Your Honor.
Mr. Jones, you've gone over the conditions of community supervision, is that right?
Yes,
I know so you haven't signed them yet, but you've gone over them and you understand what's, what you're responsible for, what's expected of you, what you're going to be held accountable to do. You understand that?
Yes, sir.
All right, yeah, he didn't sign.
I'm sorry, Judge.
It's okay. She'll take care of it. Oftentimes, I'm just signing things all the time. She catches it and brings it back to me. So, all right, give just one moment. I'm going to review the evidence. All right, Mr. Jones, court's reviewed the evidence. I do find enough evidence to convict you of this offense. The court will follow the plea agreement that you've reached with the state. Court hereby defers a finding of guilt, places you on 2 years community supervision. assesses a $1,500 fine, $180 restitution, $290 court cost, orders you to reimburse Van Zandt County $535. All right, Mr. Jones, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step forward to be fingerprinted with the deputy. And after that time, then you'll meet with Officer Ventura and she'll give you additional instructions.
I think that's all I have today at this point.
Do you have anything this afternoon?
I don't believe so.
Do you want something this afternoon? I'll probably cook something up for you.
Got a. I've got to run. I've got a halfway mediation, which I'm sure will result in nothing on a divorce.
Doesn't sound like you're going with good intentions of trying to settle the case. Mr. Schmidt, are you ready? You would call, get you out of here.
James Bustamante is ready.
Mr. Bustamante, if you'll come forward, sir. CR 21-9, CR 21-281. That's probably smart. All right, Mr. Bustamante is set for docket call today, Mr. Schmidt.
That's correct. He's set on both cases. Previously, we were here, Mr. Bustamante, their goal was to get him back in touch with the VA and actively in their mental health care. He's done that. And I've asked him to get me in contact with the doctor that is seeing now so we can provide those records for the state. I know that they were interested in seeing that progress. But we are making that progress. We'd ask that it be set for an additional docket call. I think we should be able to get something to the state probably in the next couple of weeks.
State. How long are you requesting?
Just standard 30 at
30.
Yes, sir.
I've got you coming back already on the 8th.
Yes, sir.
All right, Mr. Bustamante, the court's going to reset you for additional docket calls in each case on February 8th at 9 a.m. Once you sign that notice and get the yellow copy, you're free to go.
sir.
Joshua Hand, CR 21-168. Joshua Hand. Hand is set for a docket call.
That's correct, Judge. We're asking for an additional docket call. I think that the state and the defense is likely to be able to work it out. We're real close, I think. But just that 2-8 docket.
I don't remember objection to resetting. I was supposed to talk about this recently. If not reached a formal agreement, I think we're
Mr. Hand, why were you late to court?
There was a wreck on 243, right on the other side of 429 in Coffee County on the way down here. It was involving an 18-wheeler and 2 vehicles.
See what I'm gonna do. I'm gonna drug test Mr. Hand. I'm gonna go ahead and I'll reset the case until for docket call on February 8th. Mr. Hand, come over here, sign that notice, and then come over here and have a seat. Ralph Hanselka, CR 21-169-170. Mr. Hanselka is set for docket call.
That's correct, Judge. I don't know if the court calls, but I recently subbed in, I believe, for Mr. Ashmore. The state has provided, I have the discovery. I have not reviewed the digital. I think they provided that while I was on break. That being said, at this point in time, I just ask for an additional docket call. If I have anything, I'll bring it to the court's attention.
Any objection, State?
No, Your Honor.
All right, and I show, Mr. Hanselka, I show that you didn't report to pretrial release in December. Is there any reason for that?
Yes, I just worked it. I work a truck driver over the road. I stay out.
Did you call them and tell them that?
No,
Why not?
I just didn't. Forgot. Busy. I stay busy.
It's gonna be hard to stay busy if you're sitting in the jail.
Yes, sir.
You're not gonna be out, you're not gonna be in your truck, you're not gonna be busy. You'll be sitting your butt over there waiting for some kind of resolution in your case. You understand that?
Yes, sir.
All right, court will reset Mr. Hanselka for docket call on February 8th, but I want you to go and report to Mr. Waddell before you leave.
Yes, sir.
Is Leonard Purley here? Is John Pickney here? Are you Mr. Pickney? Hey, why don't you talk to your client? You know what I'm saying? Let's see. For the record, CR 21-268-269, State versus Avery Dairy and Plunkett set for arraignment. He is verified in custody in Dallas County. Court will reset Mr. Plunkett for arraignment on February 8th. Status of custody. Chester, are you ready? Any certain order you want?
We can just go down the docket if you'd like.
Houston Carpenter, CR 17442. Mr. Carpenter set for pretrial.
That's correct. We have no current pretrial motions. Judge, discovery was made available very end of December, the 29th. So I haven't been able to get Mr. Carpenter a time to come into my office to review that discovery. So we just asked to be set on a docket call so we have time to review that.
February 8th or 10th.
February 10th would be great.
Yeah. All right, court sets Mr. Carpenter for docket call February 10th at 9 a.m. Mr. Carpenter, I do show that you are delinquent on your pretrial supervision fees. I need you to report today and make some kind of payment, okay? Jackie Elliott, CR 21323. Is Elliott set for arraignment today?
That is correct, Judge. I have gone over the indictment with her. Her name is spelled correctly. She would waive the formal reading of the indictment and we'd enter a plea of not guilty.
All right, court will enter Ms. Elliott's plea of not guilty into the record. We will set this for pretrial hearing on February 10th, 9 a.m. Ms. Elliott, do you have your conditions of pretrial release?
Yes,
You do? Okay, so you have you know your pretrial release officer is, okay.
yes.
All right, okay, good. Once you sign the yellow copy, you're free to go. Oh, I didn't know. Yeah, I didn't know you did that. Sure. Chase Enox, CR 21324. Yes, ma'am, you're free to go. I'm sorry. Mr. Enox is set for pretrial.
Yes, right now there is no current pretrial motions. It's going to be the same announcement. Discovery was ready on the 29th of December. We just haven't had a chance to review it.
All right, court will set Mr. Enox for docket call on February 10th. Mr. Enox, I show that you're delinquent on your pretrial release fees. I also show that you're delinquent on one of your former cases where you got court costs. So you saw what happened to the gentleman earlier.
I'll get those taken care of, Judge.
Okay, please do. Otherwise, you're going to have the same fate that he did.
It will be taken care of, sir.
Thanks, sir. Free to go. Gary and Hamner, CR 21358. Mr. Hamner is set for pretrial.
That is correct, Judge. I was just appointed because Ms. Beasley retired, so we do not have discovery yet on Mr. Hamner's case. So we would just ask to be reset so we could give the DA time to get that discoverable.
Ms. Heisel or Mr. Woodwike, I know you're busy, but if you can make sure that Ms. Chester has the online discovery available today for Mr. Hamner. Ms. Chester has substituted in for Ms. Beasley. So then we'll need to make arrangements for the digital discovery as well if there is any. We'll reset Mr. Hamner then for an additional pretrial on February 10th at 9 a.m. Once you sign and get the yellow copy, you're free to go. Ms. Lane Swanson going to be a plea?
Yes, sir, and I have the pleadable agreement.
Let's go ahead. We'll do that one and then we'll circle back.
Okay, perfect. May I approach, Judge?
Yes. Lane Swanson, CR 21-252. All right, Mr. Swanson, if you will raise your right hand. You are Lane Garrett Swanson, is that correct? Mr. Swanson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, you may put your hand down. Mr. Swanson, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you're represented by your attorney, Ms. Casey Chester. Are you pleased with her representation of you?
Yes, sir.
Feel like you've had enough time to discuss the case with her and have all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and reviewed with her and signed that you do not understand? Chester, do you believe your client to be competent today?
I do.
And have you explained to him his legal rights and all of the paperwork that he signed today?
I have, Your Honor.
Do you believe that he understands all of his rights and what he signed today?
I do.
Mr. Swanson, you are charged by indictment with a third-degree felony offense of assault of a family or household member by impeding breath or circulation. That does carry a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice, and a fine not to exceed $10,000. I see that the plea agreement in this case is that you're going to plead guilty to that charge in exchange for the state's recommendation that your sentence be assessed today at 6 years confinement in TDC, with that sentence being suspended, you being placed on community supervision for 3 years, along with a fine and court costs and reimbursement fees. Is that your understanding of the plea agreement? And that's what you want the court to approve today. All right, so Mr. Swanson, I'm going to ask you, how do you plead to that charge? Guilty or not guilty?
Guilty.
Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt. Ms. Chester, any objection to the state's evidence?
No objection, Judge.
All right, state's evidence is admitted and the court takes judicial notice of Mr. Swanson's judicial confession. Anything further from the state?
No, Your Honor.
Any victim notification issues or?
Your Honor, the state is in compliance. However, there is no victim impact statement.
Thank you, Ms. Heisel. Anything further from the defense?
Nothing from the defense, Your Honor.
She's gonna fix that.
All right, the court's reviewed the evidence. I do find sufficient evidence to convict Mr. Swanson of this offense. Court will follow the plea agreement in this case. Court hereby convicts Mr. Lane Garrett Swanson of assault of a family or household member by impeding breath or circulation, third-degree felony. Court assesses his punishment at 6 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence today and place Mr. Swanson on 3 years community supervision. Order him to pay a $2,500 fine, $290 court costs, and order him to reimburse Van Zandt County $785. Sister, do you have any conditions of community supervision?
There was a mistake on the paperwork, but she's finished.
She's fixing it, okay. All right, so we'll bring it. All right, Mr. Swanson, how old are you? 21. 21's awful young to have already been convicted as a felon.
Yes, sir.
You understand that if you violate the terms and conditions of your community supervision, the state can file a motion to revoke, bring you back before this court, put you through a hearing, and if the court finds from the state's evidence that you violated your community supervision, court would revoke your community supervision.
Yes, sir.
And the sentence has already been set, right?
Yes, sir.
What is that sentence?
6 years.
6 years. So if you violate, you know what the result is.
Yes, sir.
All right, Mr. Swanson, hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted with the deputy, then report to Officer Mature here. She'll give you information about probation. All right, CR 21-293, State versus Philip, Andrew Hollister, set for docket call. Mr. Hollister is not here. Ms. Chester, you indicated that he's in a treatment facility.
Yes, it's a Recovery Unplugged, the Recovery Unplugged Treatment Center. I have a copy of the letter for the court if you would like it.
Yes.
May I approach?
Is this something that the state's aware of?
I did send a copy of the letter to them when I got it yesterday.
Yes, Your Honor, it was late yesterday. I told Ms. Chester that state would agree to a continuance based on this, but just due to the time of it, we just decided to present it to the court. But state's perfectly fine with resetting it to a date after his anticipated release of treatment, or they say in the letter they'll notify us if he is discharged, whichever one would come first.
And discovery is complete. There's nothing else that we're looking for at that.
We know how long we expect him to be in.
It's an average of 4 to 6 weeks in their recovery program. I'm not sure, just based on, just like Ms. Heisel said, if he gets released earlier than that, but I was looking at the 6 weeks just in case. That way we don't have to reset it again, waiting for him to be done. Obviously, if he gets discharged before, we would let the court know immediately.
Is this a program where he could make an appearance via Zoom?
I'm sure that that is an option. It was just so late in the day that I was not able to confirm that with them, but
I'm just not thinking about for future.
I think that they are able to do that. I just have to make sure that we give them notice, which is not going to be a problem.
All right, well, let's do this. Let's set it for available February 22nd. That'll
Yes.
make us close to that 6-week period.
Perfect. In the morning, Judge?
Yes, we'll set that for 9 a.m. on 2/22. What do you have this morning?
That's all I have this morning and this afternoon. Nothing, Judge. Just another docket. It's in one of those 3 docket days.
Don't be mad at me, but make sure you check in with Ms. Tabraham before you leave.
Okay.
You may have people for you. Hey, remember her office is that way, not that way. Down in the basement, right by the door. Mr. Sanders, you ready? Yes. Well, before I call your client, Mr. Hawkins, is your client here, Royce White? I called his name, he wasn't here earlier.
He's not yet, that's what I'm waiting for. Raise him from his hour and a half.
Okay, I was gonna let you know he wasn't here, that way if you need to leave, I was gonna get you taken care of, get you out. Okay, all right. Right, is it just Mr. Skinner today? Yes. Travis Skinner. CR 2226 and CR 265. Yes. sorry, Mr. Sanders, go ahead.
Judge, with Mr. Skinner, we'd been waiting on some lab results and we received those yesterday. And so I was just gonna ask if we could reset it one last time to go over all that with Mr. Skinner and see if we can get something
Yeah,
resolved.
we were just set for status on those labs, so we did receive them yesterday.
So I think that should be everything. I think we should be ready to proceed one way or another at this point.
Any objections to Mr. Sanders' request for additional time? Do you know how much time you need?
Judge, I was gonna say February 8th, if that would work. I know I have a few others already set that day. If that's-
February 8th is fine. All right, Mr. Skinner, we're gonna reset you for, let's see, we went from pretrial and we went to status. We'll just set it, we'll set it for pretrial.
Okay.
On 2/8. That way, if there's an issue with the lab, then
Okay,
we'll make a filing or take it up.
okay. All right. Thank you, Judge.
That'll be at 9 a.m. Chester, do you know, is Mr. Sawyer here today?
I've noticed there's somebody else standing in for today. I'm not sure who.
Mr. Sawyer, were you standing in, Mr. Sawyer?
I believe so, Judge.
Oh, okay. Okay, yeah. Well, I saw you were about to leave. Yes. Okay, good. All right, cool. That's what I want to make sure before you. So, Mr. Stevens, you ready?
Your Honor, I just see talking about my client, Ms. Williams. She is not, she is broken down in Dallas. She called Patty, said she was gonna be late. Patty said, you gotta get here. She's called our office. She's currently in Dallas, broke down. She walked a couple of miles to the gas station, to get her phone charged. She's sitting there with her phone getting charged. Anyway, could we ask her to get here or tell her to get here at 1:30 this afternoon at the jail? I don't know if she'll make it by 12 o'clock.
Sure.
That's my deal.
Sure, yeah. Was her plea going to be for time or was it going to be probation?
It's gonna be probation, Your Honor. Yes, sir. Be deferred.
And we have the plea papers and stuff.
Yes, sir. I've signed them and
I have
everything.
no
I'm just
problem.
waiting.
I have no problem. Just saying, I have her here at 1:30.
Okay. Thank you, Judge.
They're not going to let her back in the jail, in the jail docket. It may have to be that you have to come over
Oh,
here.
thanks.
But you can tell her just to show up here.
Okay.
She can wait. We'll do the jail docket and then you can either come over or they're not going to let her back in the secure facility.
Okay, so we wouldn't be able to do it back there anyway.
No,
Okay.
but if she can come here, then I don't know. How many do you have this afternoon?
I've got 3 writs.
3 writs.
Yes, sir. I
So
don't have.
we could go through those. And then,
Okay, great.
Then you can just come back over here.
That'll work, Judge. Thank you, sir.
Yeah, tell her to do that.
I'll do that. Appreciate it.
All right, so that is cause number CR 21-314. We'll recall that at 1:30. All right, Mr. Hawkins, you ready on Mr. Jones? Dennis Ray Jones? All right, this is CR 21-328. Mr. Jones, Mr. Sawyer is not here today, but he has asked Mr. Matt Hawkins, another licensed attorney in the state of Texas, to stand in. And we're set for pretrial today.
Your Honor, I believe that's right. However, speaking with Mr. Sawyer, he said he got the discovery on Monday, said that he thinks the DA's office didn't know he was the attorney of record on this case, because apparently there's some cases down at, I guess, Judge Martin's or the misdemeanor court, and so he filed a motion to transfer those up here. Got discovery this week apparently, and so he just needs time to get with his client and go over those with him. So he'll be asking for, I guess, a pass to do that.
Say, is there any objection to the request for an additional pretrial so that Mr. Sawyer can get caught up on discovery?
No, Your Honor.
All right, court will reset Mr. Jones for pretrial on February 10th at 9 a.m. Mr. Jones, once you sign and get the yellow copy, you are free to go. I am going to tell you that I've got a note here that you're delinquent close to $5,000 on 5 cases from the Van Zandt County Court of Law and 2 in this court. So looks like you're going to be picked up. If you're not going to pay, you're not going to try to make a payment, you're not going to try to do that, then warrants are going to issue for you. The next time you appear, you'll be in a jumpsuit. Understand? If you want to avoid that, then go down to the court compliance officer at the end and make your payments. If you don't, then warrants are going to issue and you're just going to go to jail. Okay. All right. Do you have a notice of setting for him?
I just text him to the judge. I don't.
Well, you got to fill this
So I'll just-
right there. You'll fill that out, and then you'll get the yellow copy, and the white copy will come right back up there. Mr. Schmidt, you ready? Oh yeah, do we have an update on Mr. Hans?
He's in the box, Judge, and understanding.
We need more time on Mr. Hand, or do we want to check on your other guy?
Judge, if we could get Mr. Pickney reset for a plea, that'd be great. And then
John Pigney, CR 21-184. All right, Mr. Pigney was set for plea today. I understand though that we don't have the plea paperwork ready.
that's correct, Judge. I'm sure I dropped the ball on contacting the DA's office and asking them to have them ready. But we'd asked it to be set for that February 8th docket day for a plea.
Any objection, mistake?
No, Your Honor, we've reached an agreement. I'm confident we've reached an agreement. I just never heard back from Mr. Schmidt. But we have no objection.
All right, court will reset Mr. Pigney then for plea on February 8th at 9 a.m. Do show that Mr. Pigney is delinquent on his pretrial release fee. So Mr. Pigney, I need you to get that resolved before you come in to plea, okay? Assuming Leonard Curley never showed up either. Leonard Curley, still not here? Okay. What's that date, Mr.
That's Mr. Hands on.
I thought that's what you were talking about.
Well, he was yes, I believe Mrs. Waddell stated that Mr. Hand was admitted to, or was positive for marijuana.
Officer Waddell. So in CR 21-168, State versus Joshua Ray Hand, court has set Mr. Hand for docket call on February 8th and ordered a urinalysis exam with Mr. Hand. Did you undertake that?
Yes, sir. Yes, sir.
What was the result?
The results was positive for marijuana and did not accept meth. He did admit to using meth. So marijuana, I'm sorry, but he did not accept responsibility for meth. So that's where we're at today. The test showed that he had used meth, but he would not admit that. The judge gave him a condition.
All right, court's gonna find that Mr. Hand has violated the conditions of his pretrial release. Court's gonna find his bail to be insufficient at this time. So, Mr. Judge, Mr. Hand, I want you to come down here and court's found your bail to be insufficient. Deputy's gonna take you to investigation. Just give me KC. I'll reset it. I didn't see it.
Just kidding.
He'd probably object to it. All right, so we'll set Miss Boyd then for docket call. Full on the 25th. What about, I've got February 8th or February 10th.
I am still specially set on 2/8, and I do think that will go away, but I'm
So
concerned.
Joe mentioned, okay, what about 20, or Tom, 22, February 22?
Let's go February 22. That's perfect.
All right, Ms. Boyd, court's going to set you for docket call on February 22nd. And I'm going to need you to report to pretrial release. I don't think you're on conditions of pretrial release yet. So just report to them. And there's going to be things that you have to do while your case is still pending hopefully until February 22nd. But you'll go back here and you'll meet with these officers. Just tell them your name, okay? You ready on that?
Mr. Justin Cannon,
Justin Lee Cannon, CR 21-282. Mr. Cannon is set for docket call.
except for docket call, I've conferred with the state. I've turned over some statements from the witness and also purportedly the victim. Ms. Heisel and the district attorney's office would like an opportunity to reach out to the victim for about this matter. It's a 20 TDCJ offer. So we're asking the court, and I think the state is in agreement for that additional opportunity for a docket call to see if we can work towards resolution.
Objection from state. All right, court will set Mr. Cannon for a docket call on February 22nd. Mr. Cannon, I show that you're nearing $200 delinquent on your pretrial release fees.
On my pretrial release.
That's what it's showing here. So sign that and come back here and meet with these officers and see if you can get that sorted out. Next client.
Judge Shelby Joslin.
Shelby Joslin, CR 20-126. Ms. Joslin is set for arraignment today.
She is set for an arraignment, Judge. She has confirmed that her name is spelled correctly both places in the indictment. She is aware of the charge against her and the date on which it is alleged to have occurred, that it's a third-degree felony, the punishment range of 2 to 10 years, the max fines. She's authorized me to waive the formal reading of the indictment and her plea of not guilty. We do have an initial plea consideration from the state, which we have conferred to her. Essentially, we're waiting on a final offer. She may or may not have some final or unadjudicated history, and that will be dependent on whatever that research shows to Mr. Woodwike, and the district attorney's office will determine what kind of probation agreement we can reach. So we're just gonna ask court to reset it for a pretrial, allow us to work that deal out.
All right, court will court will find that Ms. Jocelyn has pled not guilty. Court will enter her plea of not guilty into the record, that she's waived the formal reading of the indictment. Court will set Ms. Jocelyn for pretrial on February 22nd at 9 a.m. Yes. You're welcome.
Jesse Tashner,
Jesse Tashner, CR 21393. Mr. Tashner set for arraignment also.
he's set for arraignment, Judge. I have conferred with Mr. Tashner. He has indicated that his name, Jesse James Tashner, is spelled correctly both times in the indictment. He understands the nature and the date on which the alleged offense, possession of a controlled substance, penalty group 1 to 4, a third-degree felony, 2 to 10 years, max fines. Has authorized me to waive formal reading of the indictment, enter a plea of not guilty, and work with the state of Texas towards a plea offer, which we have already done. And so we're just asking for this to be reset so we can consider and finalize the offer. I think we will be finalizing in the next setting a 3 deferred probation, $2,500 fine, court cost reimbursement, fees, standard hours for this type of probation offense. We're asking the court to just allow us to reset it and formalize this agreement.
All right, court will enter Mr. Tashner's plea of not guilty into the record, and we'll set this for pretrial on February 22nd. Court has also signed conditions of pretrial release for Mr. Tashner. So once you sign and get the yellow copy, then report to Officer Mature over here, and she'll give you more information. So Mr. Tashner, you're gonna have conditions of pretrial release, which means you're gonna have to report. You're gonna have to pay towards your court-appointed attorney. You're gonna be drug tested. Any violation of any of these pretrial release conditions could result in the court finding your bail insufficient and you being reincarcerated. Okay?
Yes, sir.
All right, get the yellow copy and then come see Officer Mature. Ashley Blair. Is Ashley Blair here? Ashley Blair? I'll have her name called. Is that all you had this morning?
That's all I had, and I don't know if I have a contact number, but if I could have my office try to reach out to her before I'm excused for the morning.
Her bondsman is Mr. Nicholas or Roy Rockaway. If you reach to them, they'll have contact information. All right. Do you have anything separate?
I don't think I have anything else, Judge, so we're gonna just get ready for Monday.
Have a great Thursday afternoon, sir.
Thanks, Judge.
Good to see you.
Happy New Year.
Hey, Mr. Ashmore. Just for the record, CR 21165, bottom of page 1, Marshall Flores. Mr. Flores was here and
Right,
experienced
it's a health
seizure,
issue.
right? So he's been transported. I've signed the order of appointment today. So we'll just reset Mr. Flores for arraignment on 2/22 at 9 a.m.
Okay, thanks, Judge.
Jaquavia and Jackson. All right, Mr. All right, Mr. Jackson, have you requested a court-appointed attorney? All right, if you'll give that paperwork to Ms. Tabraham, and then I'll recall your case in a moment, okay? Christopher Nash. And so you can go ahead and have a seat, and when she brings me that paperwork, I'll go through it and I'll call you back up. Is Mr. Nash the same? Okay, if you haven't turned in your paperwork yet, then just turn that in and I'll recall your case. Dakota White. All right, you're Dakota Lloyd White, is that right? Yes, sir. All right, this is CR 21375. Mr. White, you requested a court-appointed attorney, and the court has looked over your application, and I find that you do not meet the financial requirements for a court-appointed attorney. So at this point, you got two options. You can represent yourself, or you can hire an attorney. I'd be willing to reset your case today to give you time to gather funds to hire an attorney to represent you on this third-degree felony charge of possession of a controlled substance. A third-degree felony in the state of Texas carries a range of punishment not less than 2 years or more than 10 years in prison. So it's a very serious charge. So do you want me to reset your case and give you time to try to hire an attorney? All right, so I'm going to reset you until February 10th. So, Mr. White, I would encourage you to contact multiple attorneys. If you contact an attorney and you aren't able to hire him or her or reach some type of agreement, then you call me. And that way you can call a bunch of them so that you have a good idea of what it costs and see if you can get someone to represent you, okay? So I will see you back on February 10th. Jeffrey Viramontes. This is CR 21374. Mr. Viramontes, you are charged by indictment with a second-degree felony offense of possession of a controlled substance, penalty group 2, between 4 grams and 400 grams. If convicted and sentenced for that charge, you could be facing a possible range from 2 years all the way up to a maximum of 20 years in prison and a $10,000 fine. I find that you have requested a court-appointed attorney, and based on the information you provided, you do not qualify for court-appointed counsel. So same thing that I told the other gentleman, I can reset your case and give you an opportunity to try to hire an attorney on this felony charge. You also have the right to represent yourself. I just would not advise that at this point. Okay, if I reset you to February 10th.
Can you give me 5 more days after that?
How many more days?
5.
5. February 22nd?
Yeah.
All right, court will reset you to February 22nd. Now, you'll be coming back at 9 a.m. You're free to go. Sir.
Thank you.
Tamara Reen. CR 21366. Ms. Reen, you've been charged by indictment with the third-degree felony offense of driving while intoxicated, third or more. If convicted and sentenced in this offense, you'll be facing a punishment range of not less than 2 years or more than 10 years in prison, and a fine of not more than $10,000. Are you gonna try to hire an attorney? Have you been speaking with an attorney to try to hire him to represent you in this case?
Well, I did try to do that, sir, but my husband passed last July and I've had a difficult time getting things together to hire who I wanted was Mr. White. And I wasn't able to come up with all the money to do that. So
If I give you more time, do you believe you'll be able to come up with?
I don't think so because this left leg, the ligament's torn. I have all that, and then my right leg, the ankle was broken. So I had two not giving legs. So I'm on leave with a taxi company. So I'm not able to work to get that extra income because I'm living on my survivor's pension from my husband's passing. So at this point, I don't think given another month, I could come up with that kind of money right away. And my daughter is trying to figure out something, but I don't think that's a month is going to be enough time for me to get all that together.
I give you more than a month?
Can my daughter speak or is it?
No, I speak with you. If you want to go step over to talk with her for a second, that's fine.
Yes. Can I just go ahead with the court appointed because I've got more bills going out than coming in. And I was just praying for a miracle. Because I like the Whites. I believe that what's going to happen, is going to happen. So what I'll do is just, if I could, go ahead with the court appointed because I don't want to, if it's a month or 2 months, or I don't know how many months you'll allow me. Oh, in 4 to 6 months, sure. I could, I'm going back to work plus that money. But right away, in a month or two, I don't think I'll be able to work fast enough to get a hold of that. My daughter wants to help, but she's got 3 babies she's raising. I don't want to depend on anybody but myself to do this.
You listed that you have probation fees. Are you on probation?
I'm sorry?
Are you on probation? You listed that you have
I'm on
probation.
pre-trial and I just talked to Mr.
Ms.
Waddell.
Waddell.
I'm gonna have those caught up today. I'm going straight over there to do that. I've been trying to hold on to every dime but I've had to downgrade since my husband passed. I've had to go from a 3-bedroom to a 1-bedroom to, it's just been.
All right, I'll tell you what, have a seat. And I'll recall your case in just a minute.
Okay.
James Rife.
Morning, Your Honor.
Good morning, sir. All right, this is CR 21-307-308, State versus James Clifton Rife. Mr. Rife, I believe I've reset you a couple times to give you time to hire an attorney.
Yes, sir.
Yeah, do you have any updates for me?
Well, the only update I have is that he had a court this morning at 10 and he got another court at 1:30 and that's the only thing I have and I'm gonna go give him some money today.
Who is that?
Jim Huger.
I think this is what we talked about last time you were here, right?
Well, I hired him. I already been and hired him. I've already retained him. I talked to his legal assistant this morning, and I was under the impression that he had already contacted the courts and maybe reset it already. But I don't know if that was for sure.
All right, I'll tell you what, have a seat and I'll have my coordinator contact their office and we'll see.
Okay, can I go to the bathroom?
Yes, sir. Thank you. Ishmael Rodriguez. Mr. Rodriguez, you're charged by indictment with a state jail felony offense of driving while intoxicated with a child under 15 years of age. state jail felony, carries a range of punishment, if convicted and sentenced to not less than 6 months or more than 2 years in a state jail prison. Mr. Rodriguez, are you going to hire an attorney to represent you?
Yes.
And if I reset you until February 10th, do you believe that'll give you enough time to hire an attorney?
Can you give me a little bit longer?
February 22nd?
Second?
Can you do that? All right, court will reset you until February 22nd. Ernest Wilkerson? Yes. All right, for the record, CR 1883, the state has tendered a motion to withdraw the motion to revoke and terminate. So court has granted the motion to withdraw the state's motion to revoke. And Mr. Wilkerson, I'm going to go ahead and terminate your community service today. You'll be done. So I want you to meet with Mr. White and Officer Mature here. They'll give you more information. Okay, so thank you, sir. Go ahead. Carl Caper here. Daniel Downing. Kendrick Irvin. So Ms. Tabrum's coming back with Mr. Quavian Jackson and Mr. Nash. Mr. Green, Mr. Rye.
And y'all took care of Mr. Wilkerson.
Took care of Mr. Wilkerson. What about Essie Miniweathers? No. Luis Vasquez. Ladary Ward. All right, this is CR 21397. Am I saying your name right? Is it Ladary? State versus Ladary D. Anthony Ward. Mr. Ward, you've been charged by indictment with possession of marijuana, 4 ounces to 5 pounds. That is a state jail felony. If convicted of that offense and sentenced, the range of punishment is not less than 6 months or more than 2 years in a state jail prison and a fine not to exceed $10,000. Do you intend to hire an attorney to represent you?
Actually, the arresting officer, I actually turned the drugs in. It wasn't my drugs. But when I got there, they booked me in. But 2 days later, after I left and came back to get my phone, the officer the main officer, the sheriff, he was like, he told me if I would have waited to get bonded out, because I had called to get bonded out that same night. I didn't know why I was. Because I turned the drugs in, it wasn't my drugs, like, you know.
Well, I don't want you to say too much, but I'll tell you this. The state of Texas is represented by their prosecutors, and the offense report, the case report from the arresting officers was turned into the DA's office. The DA's office took it to the grand jury. The grand jury has indicted you. They've legally accused you and charged you with possession of marijuana. So at this point, you got to make a decision on, you're going to have to defend yourself, and you're going to defend yourself either by hiring an attorney to represent you. If you feel like you're poor enough that you don't have enough money to hire an attorney, you can request a court-appointed attorney, or you can represent yourself. So if I give you more time, if I reset your case, do you feel like you'd have enough time to give you an opportunity to hire an attorney to come down here and try to resolve the charges and look into these issues that you're bringing up? If I reset you until February 10th, gives you more than 30 days. Okay, is that fine?
Yes, sir.
Okay. All right, court will reset Mr. Ward then for arraignment on February 10th and to hire an attorney. So Mr. Ward, when you get that, before you go, when you hire the attorney, then have them contact the Van Zandt County Criminal District Attorney's Office of Prosecutors. And he or she can go ahead and start working on your case with them, okay? All right, you're free to go. We'll see you back on that day at 9 o'clock.
Just so you're aware, there is a victim impact statement on this plea.
Yeah, Casey. What's your formal first name? Keith. Well, we're about to start. Keith. I said we're about to start.
Oh.
Keith. Let's see.
It's even on my half visible record.
Mr. Jackson, the court has reviewed your request for court-appointed attorney, finds that you are eligible. The court will find you to be indigent at this time. Court has appointed Honorable Casey Ashmore to represent you. Mr. Ashmore, have you met Mr. Jackson?
Not yet, Your Honor.
All right, this is Mr. Casey Ashmore. This is Mr. Jaquavian Jackson. Mr. Jackson is set for arraignment today on a possession of controlled substance, another group 2, 4 grams to 400 grams. And Ms. Tabraham provide you a copy of the document. I'll give you a moment if you want to go over that with Mr. Jackson. Yes, yes.
She moves her phone back.
Oh, I thought she was saying she needs to use it.
Hold up. No, right there, it's fine. All right, Mr. Reif, I got a hold of Mr. Hugler's office. He says that you have been giving him some money. He says that you're not quite through retaining him, and he's expecting one more payment from you.
Yes,
Okay. He says you're supposed to be making that today.
yes.
Okay. You know, there's a difference between retaining someone and giving them all the money versus making payments. So you need to tell me these things.
Okay, yeah, I'm sorry, Your Honor. Yes, I was supposed to, I went and made a payment to him, and I was supposed to have made some prior payments, and I tried to go make the payments, but there wasn't anybody in the office, and I tried to call him, and I couldn't get a hold of anybody, and that's the reason I haven't made any more payments.
All right, so I'm going to reset you one more time to give you a chance to finish it up. If you come back next time without Mr. Hugler, then I'm probably just going to find your bail insufficient and put you in jail, and we'll figure it out after that. Okay?
Fair enough, Your Honor.
All right. I just want you to know where we're heading. So that's I'm sorry, that's CR 21 307 and 308. James Clifton. Right.
Okay. Yes, sir.
And that'll be we'll do February 10th for arraignment and hire attorney.
Thank you very much.
Thank you, Mr. Rice.
Can I go through it later?
Mr. Ashburn, you ready for Mr.
I am,
Jackson?
thank you, Judge.
All right, Mr. Jackson, if you'll step back up, go back on the record, CR 21-361.
Judge, thank you for giving us a moment. Waiver and I have visited, he has confirmed that his name is spelled correctly, both places in the indictment. He understands the nature of the allegations that he was charged with carrying synthetic marijuana. Can't say that word, on or about March 19, 2021. More than 4, but less than 400 grams of second-degree felony, the punishment range of 2 to 20 years and $10,000 fine. He's authorized me to plead not guilty on his behalf to negotiate with the state and see if we can resolve this matter. So I'm going to ask for a reset, to get discovery. 222 is what I asked for earlier. Would be so inclined to allow that case. On this case, we appreciate it.
All right, the court will find that Mr. Jackson has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record and will set pretrial on February 22nd at 9 a.m. Mr. Jackson, you're going to sign this notice of appearance. We'll give you a yellow copy. It'll have that date on there. Court's going to also have conditions of pretrial release that you're going to have to abide by. So I want you to, after you get that yellow copy, check in with Officer Bashir right here, and she'll give you further instructions. Okay. Mr. White, you ready?
Yes.
Mr. Ragland.
We're ready to go, whoever you're ready to go on.
Mitchell Ragland, CR 21-185. All right, Mr. Ragland, if you'll raise your right hand, sir. Mr. Ragland, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
All right, you may put your hand down. You are Mitchell Wade Ragland, is that right?
Yes, sir.
And Mr. Ragland, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes, I am.
You feel like you've had enough time to discuss your case with him and have all your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No.
Mr. White, do you believe Mr. Ragland to be competent today?
Your Honor, I believe that Mr. Ragland is competent, understands the proceedings that are pending against him here today in front of the court. There's some waivers of his rights. I believe he waived those rights knowingly, intelligently, and voluntarily.
All right, Mr. Ragland, you are charged by indictment with a second-degree felony offense of aggravated assault causes serious bodily injury, carries a range of punishment if convicted and sentenced between 2 years to a maximum 20 years, and a fine not to exceed $10,000. I see the plea agreement is that you're going to plead guilty to that charge. The state's recommending that your punishment be assessed today at 10 years confinement in prison, with that sentence being suspended and you being placed on community supervision or probation for 5 years, plus fine, court costs, and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
All right, understanding the range of punishment and the plea agreement, Mr. Ragland, how do you plead to that charge?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir. I am.
Has anyone threatened, forced, or pressured you to plead guilty today, Mr. Ragland?
No, sir.
All right, court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
We have no objection.
State's evidence is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, there's a couple of matters I would like to take up for record purposes. The first of which is when reviewing the evidence, you will notice that this is a 2-count indictment. The state is going to abandon count 2, proceed with count 1. That is reflected in the paperwork before you, but just I didn't want you to see that during the review and have questions about that. And then, Your Honor, there is a victim impact statement that was forwarded to the court this morning. We would ask you to review that before pronouncing sentence.
Thank you, Ms. Hazel. Anything further from the defense? Ms. Hazel, is the victim supportive of the plea?
Your Honor, I have not spoken with her. I know she has, I could be able to advise about their specifics of their conversation.
All right, the court's reviewed the evidence. The court has also reviewed the victim impact statement form. Court will find that there is sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement based on the recommendation of the state of Texas. Court hereby convicts Ms. Joel Wade Ragland of aggravated assault causes serious bodily injury. Court will assess his sentence at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will suspend that sentence and place him on community supervision for 5 years. Order him to pay a $2,500 fine, $290 court costs, and $35 reimbursement fees. All right, Mr. Ragland, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions. I'm going to have you step forward to be fingerprinted with the deputy and then report to Officer Ventura. Ms. Heisel, I believe you'll need to sign that as well. And then I'll give that back to you. Isaiah Rosser. All right, Mr. Rosser, this is CR 21239. Mr. Rosser, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, you may put your hand down. Your name is Isaiah Jabrier Rosser, is that correct? Jabrier Rosser. And Mr. Rosser, are you a United States citizen? Yes, sir. Do you read, write, and speak English? Yes, sir. Have you ever been diagnosed with any type of mental condition? No, sir. In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you? Yes, sir. Feel like you've had enough time to review the case with him and have all your legal questions answered? Yes, sir. Is there anything about this paperwork that you've read and signed today that you do not understand? Yes, sir. All right, Mr. White, do you believe Mr. Rosser to be competent today?
Your Honor, I believe that Mr. Rosser is competent. He understands the proceedings that are pending against him here today. As you court will know, this is for a PTI. I've gone over each and every of the documents with him, specifically the waiver of jury trial. He understands that nobody can force him to give that up. I believe that he's giving that right up knowingly, intelligently, voluntarily.
All right, I'll need the state to sign the waiver of jury trial and also the certificate of discovery.
Someday I'll figure it all out, Judge. Someday.
All right, Mr. Rosser, you understand that you're giving up several important rights today in order to get into this pre-trial intervention contract program. So, as Mr. White said, you'd be waiving your right to a trial by jury. So, and you understand that when you give up that right, it may not be restored to you. Yes, sir. So if I approve this and you go into this contract program, and if you end up violating any of the terms, then the state of Texas's prosecutors can bring you back to court, as this court has been set you for trial. And that trial would not be before a jury of your peers, it would be before this court. Yes, sir. And in doing that, you understand that it has to be your own desire to waive your right to a jury trial. Right. Has anyone threatened, forced, or pressured you to make you feel like you had to waive your right to a jury trial, a speedy trial, or your rights to expunction of the DA's records or the probation records?
I don't know.
So you're doing this of your own free will and accord, is that right? All right, the court will approve the pretrial intervention contract and all of the waivers included therein. The court finds that Mr. Rosser has been admonished of his rights and has intentionally, knowingly, voluntarily waived those. The court will approve the contract for a period of 2 years on the charge of possession of controlled substance of Millie Group 2, greater than or equal to 4 grams, less than 400 grams. All right, Mr. Rosser. Yes, sir.
We have not filed, they are unfiled, state will formally reject both of those charges. On entry of the not completion.
Is that part of this contract? I don't think that's in here.
No, it's just an agreement between myself and Mr. White to resolve all of his business here. Their unfiled misdemeanors, we will formally reject them as soon as this.
Your Honor, that was my understanding of our agreement.
All right, Mr. Rosser, I'm going to approve the contract and I've already signed it. So I'm going to have you come meet with the pretrial intervention probation officer, and she'll give you more information about what to do next. Okay. So you can come on in here, go through these doors, and meet with Officer Mitchell.
One other thing, Your Honor, as per my custom intervention agreements, my office will be paying out of my firm's operating account the PTI fee for the day.
Okay.
So if something happens, it's my fault.
Well, I figured if it's not paid, it's the VA's requirement, so they would let us know.
Bill, PTI, state's comfortable with that, that understanding.
All right. Come on, Mr. Rosser. Mr. Reeves. This is CR 21-154, State versus Jeremy Alexander Reeves. Mr. Reeves, if you'll raise your right hand, sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, this is also, I'm sorry, cause number CR 21-187. All right, you are Jeremy Alexander Reeves, is that right?
Yes, sir.
And Mr. Reeves, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Never been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss your case with him, have all your legal questions answered?
Yes, sir.
Anything about the paperwork that you do not understand?
No, sir.
Mr. White, you believe Mr. Reeves to be competent today?
Your Honor, I believe that Mr. Reeves is competent. I believe that he understands the proceedings that are pending against him here today. Before the court, we have 2 separate documents for pleas. I've gone over the waiver of rights in each document. I believe he's waived those rights knowingly, intelligently, and voluntarily. If the court goes along with the plea agreement, he's placed on deferred adjudication for a period of 2 years. I've explained to Mr. Reeves the benefits and the potential pitfalls of entering into such an agreement with the state. Most notably, if he violates any term of his plea agreement and the probation conditions, the court will hold a hearing to just determine whether or not he did so. If the court finds that he did so by preponderance of the evidence, or has the ability to sentence him up to 10 years or 20 years in the penitentiary and a fine not to exceed $10,000.
Thank you, Mr. White. All right, Mr. Reeves, in cause number CR 21-154, you are charged by information with a Class B misdemeanor offense of driving while intoxicated. The range of punishment for a Class B misdemeanor is confinement in Van Zandt County Jail for a period of not more than 180 days and a fine not more than $2,000. I see the plea agreement in this case is that you would be pleading guilty to that charge. The state's recommendation is that your sentence be set at the maximum 180 days in the county jail, with that being suspended and you being placed on community supervision or probation for 1 year In addition to that, you would have $100 fine and court costs and reimbursement fees. In cause number CR 21187, you are charged by indictment with a second-degree felony offense of assault of a peace officer. Court finds that the range of punishment for a second-degree felony is confinement in the Texas Department of Criminal Justice for a period of not less than 2 years or more than 20 years, and a fine not more than $10,000. I see in this case that you would be pleading guilty to that charge in your plea agreement. The state is recommending to the court that the court defer a finding of guilt, meaning that court defer finding you guilty today and waiting to see if you successfully complete your probationary period. And that would be for 2 years. And then you would have a $2,500 fine, court costs, and reimbursement fees. And the state's going to be dismissing a resisting arrest, search, or transport offense. Is that your understanding of the plea agreements, Mr. Reeves?
Yes, sir.
That's what you're asking the court to approve today?
Yes, sir.
All right, Mr. Reeves, understanding the range of punishment for each one of these charges and the plea agreements, then let me ask you, how do you plead to driving while intoxicated?
I plead guilty, sir.
How do you plead to assault of a peace officer?
Guilty, sir.
Are you pleading guilty to each one of those crimes because you are guilty of committing each one of those crimes?
Yes, sir.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty to either one?
No, sir.
Court will accept the defendant's plea of guilt at this time. Mr. White, any objection to states one?
No objection.
All right, states one is admitted in each cause respectively. The court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, this is not a required notification case. I have spoken with the trooper. He is comfortable with it. While Mr. Reeves did, according to the police report, kick him in the arm. It caused some pain, but no lasting damage. He's comfortable with it.
Anything further from the defense?
I would agree with that assessment.
Assuming that both of these occurred out of the same transaction?
Yes, sir. It did, yes, sir.
All right, court's reviewed the evidence. I find that there is sufficient evidence to convict Mr. Reeves of each offense. The court will follow the plea agreement and the recommendation of the state of Texas. Court hereby convicts Mr. Reeves of driving while intoxicated, assesses his punishment at 180 days confinement in the county jail. Court will suspend that sentence today, place him on community supervision for 1 year, order him to pay a $100 fine, $270 court costs, and $15 reimbursement fees. Court will order that any time in this case to run concurrent, I guess with community supervision in CR 21187. In CR 21187, the court will defer a finding of guilt on the charge of second-degree felony assault of a peace officer. Court will defer that finding for a period of 2 years, place him on community supervision, order him to pay a $2,500 fine, $290 court costs, $35 reimbursement fees. The court will dismiss under section 1245, take into consideration DA 2020-1209, a resisting arrest, search, or transport. All right, Mr. Reeves, you're hereby remanded to the custody of the Van Dyke County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Have you step forward here with the deputy to be fingerprinted? I've got one more for you. Put it here. I'll give the rest to Rachel. Mr. Ashmore, you ready on the screen?
Yes, Judge.
All right, Mr. Reem, if you'll step up. Okay. Mr. Reem, if you'll step up, please. It's cause number CR 21366, State versus Tamara Lee Reem. Court has appointed the Honorable Casey Ashmore to represent Ms. Reem. Mr. Ashmore, have you an opportunity to review the indictment of your client?
I have, Judge. Tamara Lee Reem has confirmed that her name is spelled correctly throughout the indictment. She understands the nature of the allegation, that it's a third-degree felony with 2 priors. She understands and has read through the first and second paragraphs of the indictment, so she knows that there's an allegation of alcohol-related driving offense July 5th, 2021 in this county, and, drug or alcohol-related driving offense in this county on July 2021, and that there's prior convictions in 1994 and in Gregg County and in 1998 in Smith County regarding other offenses. That being said, she's authorized me to enter a plea of not guilty and seek to resolve this with our maybe not by our next pretrial hearing, but we're going to work diligently towards that. I'd ask the court to please set this on 2/22 and allow me some time to get discovery from the state and work through these issues.
All right, the court will find that she has waived the formal requirements of arraignment. The court will enter her plea of not guilty into the record and set free trial on February 22nd.
Thank you, Judge.
And Ms. Reem, once you sign and get the yellow copy, then I want you to report to pretrial release and make a payment towards your pretrial release fees.
Sure.
Yes.
She was showing her
Broken.